Hello and welcome to the fifth session in our latest employment law series. This one is called Cracking the Code, Tactics for Discrimination Cases. My name is Iris Ferber Casey and I am an employment barrister at 42 BR Barristers.
And I'm Karen Minto. I'm also an employment law barrister at 42 BR. Today we'll be talking about lists of issues, anonymity and discrimination evidence, specifically looking at statistics and comparators.
Before we do that, Karen, let me give everybody some pro forma.
Yes.
About this event. If you want to know about other webinars that have already aired or that are going to air in future, please do go to our website, 42br.com. All the webinars are listed there. If you have any questions for us, as Karen and I are chatting away about tactics in discrimination cases, please make sure you don't put them in the chat because they won't be seen if they go in the chat. Please put them in the Q&A box and we will endeavour to answer as many of your questions as we can. We'll do that at the end of the session, and if we run out of time, which knowing us, because we might chat away for ages, we may run out of time. If that happens, we will follow up on your questions by email. If you're watching this webinar as a recording, please don't put any questions on the Q&A or the chat because no one will see them. Send your questions instead to the following email address if you are watching this as a recording, events@42br.com. And then finally, please note that an email with the recording and a feedback form is going to be circulated to you in the next few days. All right, Karen, I'm now turning to you.
Right.
So you said we were going to talk about lists of issues, anonymity, discrimination. Is there any particular reason for picking those three topics?
Yeah, well, all of them have come up in recent Court of Appeal or EAT cases, obviously, and we all know about moustache, partly because it's got such a good name, but also because everybody deals with lists of issues. We deal with them every day. It's something we have to deal with, and it's something that helps us enormously.
It does, but it also, of course, generates the occasional nightmare appeal when things go wrong. And the Moustache case, which to give it its full and glorious name, is Miss Nicole Moustache and the Chelsea and Westminster Hospital NHS Foundation Trust.
Yes,
right. It's from this year.
Yeah.
It went to the Court of Appeal, and if I'll give you a bit of a story.
Okay.
To tell you what happened in the case, and then we can have a bit of a chat about what the Court of Appeal did with it, which was perhaps to many of us a quite unexpected outcome. But actually, despite being unexpected, perhaps quite a useful and interesting case, and a good one to start this webinar with. So Ms. Moustache was a litigant in person. That's very common in cases where lists of issues become a problem later on in the litigation. She had an employment tribunal claim for direct discrimination dealing with both disability and age. Yeah. And that was to do with handling of a grievance that she had submitted while she remained in employment, and it was to do with bullying. She also made a Section 15 discrimination arising from disability claim in the same ET1, and she described feeling anxious about what had happened to her. She described having had a panic attack at work and being signed off. But when she was asked to give further and better particulars about all of that during the course of that claim, she described her disability as a mobility disability based on a fact she'd had a hip replacement. And there were various stages of that claim at which the tribunal ordered the parties to prepare a list of issues. Respondent was directed to start that process. They prepared the NHS Trust's lawyers prepared a draft list of issues and sent a copy to Miss Moustache, and she confirmed she agreed to the list of issues. Yeah. Then, as sometimes happens in these cases, she got sacked. She got sacked for long-term absence, basically. Yeah. And she started a new tribunal claim for unfair dismissal, just unfair dismissal. She did not tick the discrimination box at all. Yeah. She just ticked the unfair dismissal box in that second claim. And she claimed that she'd been unfairly dismissed for being on long-term sick leave. She referred in the claim form to the fact she had an ongoing disability and age discrimination claim, but no more than that. And then those claims were consolidated and went to trial as per those pleaded claims. She put in a witness statement in which she said, so this is the witness statement for trial,
Yeah.
and in that she said that that there was a deterioration in her mental health during the course of these events, and she said that that amounted to a disability. So that's in her witness statement.
Yeah.
But it's not what her two claim forms had said.
No, it's mobility.
That was mobility.
Yeah.
And perhaps you might think, in hindsight, quite cleverly, the respondent, shortly before trial, revised the list of issues in accordance with the full pleadings, but not in accordance with the witness statement, just in accordance with the claim forms, sent it to her. She then confirmed that list of issues as correct. Then a trial, and that list of issues referred to her disability as being a mobility issue relating only to hip replacement, no mention of mental health impairments. And under the heading Section 15, discrimination arising from disability, this list of issues just referred to a single incident of unfavourable treatment at a particular meeting relating to the grievance, which dated back to her original claim form. So it came from her original claim form. No reference to mental impairment, no reference to Section 15 claim relating to her dismissal, despite those things being set out in her witness statement pretty clearly, but they weren't in the claim form. What happens next? The tribunal hears her claims and dismisses all of them based on an analysis of the claims in the list of issues only. And those of us who are familiar with the recent run of EAT cases about lists of issues will not be surprised to hear that EAT did not like that, overturned that judgment, and said that the tribunal had erred in law by failing to address the existence of a discriminatory Section 15 dismissal, because there was a reference to that in the claim form, and it was definitely obvious from her witness statement. And the failure to sit down, metaphorically sit down at the start of the trial and revisit the list of issues, having received her witness statement and then reading that back to the claim form, the EAT said that was an error of law. And the trust appeals, the Court of Appeal.
Well, and we were all very interested in this case because, of course, we're dealing with them every day. Court of Appeal considered the tribunal's duties to not be to interrogate the list of issues, to interrogate witness statements and add them to the claim, essentially. So they made 4 important general points. The first was that the issues raised by the parties are those which come clearly from an objective analysis of the statements of case, i.e. the ET one, which the Court of Appeal made very clear is user-friendly and is that way because we have a lot of litigants in person. The tribunal then should not be expected to analyse the party's case by reference to documents which come after the pleadings, which, makes sense.
It does, because we often have, 100-page witness statements of litigants in person, which raise all sorts of things that are not in the pleadings.
And the Court of Appeal said that witness statements don't have the same status as an ET1. They're not pleadings, and also neither do submissions. So that was the first point. You look at the ET1, and that is where you derive your claim. Second point, where a party seeks the tribunal's ruling on an issue that comes from an objective analysis of the statements of case, the tribunal does have a duty to address that issue. So if it's in the ET1, the tribunal has a positive duty to address the issues in the claim.
Right. And if it's not in the ET1, it definitely doesn't have a duty to do that.
No, that's the negative side. But the core function of the tribunal is to interrogate the ET1.
So that was points 1 and 2.
Points 1 and 2. Point 3, which was an interesting one. Employment tribunal cases are adversarial. And the primary onus lies on the parties, therefore, to identify what claims they wish to bring and how. They so a litigant in person needs to set out what claims they wish to advance, and the respondent needs to respond to whichever parts of that claim they wish to deal with. It's not a tribunal having a sort of general investigation of what happened. No, exactly. And sorting it out for itself. Yeah, exactly. And that was their fourth point. The fourth point was that the tribunal's role isn't inquisitorial or investigative. It has to perform its functions in line with the overriding objective and its duties of fairness to both parties, fairly and justly, and advancing and looking at the evidence in the case is not their primary role. Their primary role is to give justice to both sides. So the tribunal might think it's appropriate, and there is guidance in Moustache to this issue, to help a litigant in person.
Yes,
of course,
especially if there's something in the claim form that they're trying to say and it isn't clear what it is.
No, exactly. I mean, we all know that a litigant in person is not going to have necessarily have the language that we would have, because we've been doing this for years. And of course, then the tribunal has scope to explore by way of clarification, but no more than that. But what, to the extent to which they do that, it won't be an error of law.
Right. And I mean, basically, one of the things I take from Moustache is that some tribunal judges and panels will revisit lists of issues at the start of a trial, maybe even go, or quite possibly go back to the claim form, recheck everything and see whether it still marries up to what's in the list of issues that is in front of the tribunal. Other judges and panels won't want to do that and will just say, well, you've agreed this list of issues, that's all I'm dealing with. Either one of those is not really appealable.
No.
Those are both permissible ways of using lists of issues at a trial, as long as they're agreed lists of issues.
Yes, but as long as it's evident from the ET1, because you said, and you do get this a lot, the tribunal will say, right, does this still marry up? Still being the operative word. Well, it should have married up
when it was drafted.
And if it doesn't relate to the ET1, then
there's probably,
you can't add things in.
No. And one of the things that came out of Moustache, wasn't it, when they applied these principles to the facts in Moustache, is that the list of issues is a case management tool. Its purpose is to summarise the pleadings, and tribunals entitled, therefore, to confine itself to an agreed list of issues on the basis that that's an agreed summary of the pleadings. But the corollary of that is that if a tribunal is being criticised for not eliciting some other claim from the claimant, which is not in the claim form, which is not in the ET1, the only way a tribunal could do that would be by stepping into the arena and inviting a claimant to amend their claim form to add, in this case, a Section 15 discriminatory dismissal claim. That's the only way in Moustache that the tribunal could have elicited that claim from the claimant, would have been by saying to her, don't you want to make an application to amend your claim forms to add this claim, because it seems to us that that's what you're really, that's what really happened to you, is if the facts are as you say they are.
And more often than not, the tribunal will do that. They will say to the claimant, you cannot make a new claim, make an application to amend. Often prompted by...
Well, and interestingly, sorry, you were going to say...
Yeah, often prompted by the respondent saying they can't say this.
Right, but another part of that, which comes from Moustache as well, stated by the Court of Appeal, is that the tribunal has a duty of impartiality not to embark on an entirely self-guided invitation to a claimant to amend their claim. It's one thing for a respondent to say, at a case management hearing, well, this claimant is now saying X, Y, and Z. That's not in their claim. So if they want to raise that, they need to make an application to amend. That happens all the time. We see that in case management hearings. That's quite different from claimant doesn't raise something, respondent doesn't raise something, but the judge says to the claimant at a case management hearing, don't you really actually have a claim of discriminatory dismissal under Section 15?
Or on the day of the
or indeed on the first day of trial. Don't you want to make an application? That sort of step, Moustache says, is an error of law, which a respondent can potentially challenge. So that is quite a stark difference, I think, in terms of the concepts applicable to case management than we've had from the EAT in recent cases.
Yeah.
So Karen, what can we, so that's us discussing the case. What can we draw out from that in terms of tactics? Particularly tactics, I think, for respondents.
Yeah, they
in claims
definitely,
where litigants in person are on the other side.
well, they definitely arise, don't they, when you're acting for a respondent against a litigant in person, because one would hope that a respondent who is represented would have responded to the claim, and the claim is a positive step. If it doesn't have a positive case, then it doesn't exist.
Right, and if a claimant is represented, then the tribunal will expect that whatever is in the particulars of claim is the claim.
Yeah.
That's generally pretty straightforward.
Yeah.
So these tactics applying to lists of issues and the problems with lists of issues will arise where the claimant is a litigant.
Absolutely, yeah.
Right.
I mean, it's very rarely a problem where the claimant is represented. Of course, there may be errors, but it's much less likely.
Okay, so what are we, as a respondent representative then, in a case like this, what are our tactics?
Okay.
Now, post-moustache.
I would say,
Yeah.
draft the list of issues yourself.
Yeah.
That's
So
the first thing.
respondent draft the list of issues.
Respondent
Right.
draft the list of issues.
Okay. Yeah, that makes sense. That's what the clever trust did in Moustache. They got ahead of it and they put the list together themselves.
Exactly. Draft the list of issues using the ET1 claim form.
Right.
Very specifically, and you know, you can't pretend that there's not a claim there. You have to take, you have to assist the claimant.
Yes. And you have the
That's your
overriding
job.
objective requires a respondent to translate what's in the claim form into a draft list of issues if they're going to offer to do the first draft of that.
But you can draft the list of issues very precisely.
Yeah.
And as narrowly as required, justly, on the claim form, on the face of the claim form. You're not going to imply anything into it.
No,
that's
don't
not
add
there.
all kinds of queries about things that aren't necessarily there. Don't be too, there's no need to be too helpful.
No.
You're basically inviting a widening of the claim if you do that. You're entitled to read what it says and turn it into a list of issues.
Absolutely. And that is totally in line with the overriding objective and our duties as well. And then invite the claimant to agree, which again is what the trust did in Moustache. The claimant did agree the list of issues.
Yeah, absolutely. And I mean, we were talking about this before, and I didn't mention this point. So this is a new one for you know, in terms of our conversation. But so I don't know what you're going to say about this.
Right.
But I've had cases, particularly where we've had multiple case management hearings with a litigant in person claimant, where every time the tribunal invites the claimant to agree the amended list of issues, there are additional attempted changes and amendments, and you go round and round 5 or 6 case management hearings.
Yeah.
In those sorts of cases, I've started asking, once we get to the final version, for an order from the tribunal that all claims not expressly set out in the final version of the list of issues are hereby withdrawn.
Yeah.
And the claimant is invited to agree to that. Now, I you know, you can only do that in a case where that's justified, I suppose. But I do wonder whether that might be something to try to do a little bit more often. I don't know if you've ever taken that step, but I can imagine where
I have, and it's not always it's been something the tribunal's been prepared to order.
No, that's right.
More often than not, up until recently, the tribunals will allow the claimant a lot of leeway.
Yeah.
And I think perhaps I think Moustache has dialed that back a little bit.
Yes, we'll see whether it does pan out that way in future cases. But I do wonder whether it might be something we could start to do more of, and perhaps in less extreme cases than where you're sort of 6 case management hearings down the line, just to say, right, we've agreed a list of issues. Can we have an order that both parties agree that those are the only issues in the case, that there's nothing, that whatever isn't, anything that isn't in the list of issues is hereby withdrawn.
I mean, it's very important to remember, isn't it, that proportionality is also part of
exactly. And I don't think, I mean, perhaps our friend here, if we're respondent representatives in these cases where the litigant's in person on the other side, our friend is the tribunal backlog, because maybe it's going to be pushing at an open door to persuade a tribunal to keep the case proportionate by agreeing that this list of issues cannot be expanded or changed in future because the claimant is actually expressly withdrawing anything that isn't in this list of issues.
And actually, and the other thing
Maybe.
I'm finding quite useful, Moustache has been quite useful in helping me persuade a tribunal to actively help a litigant in person produce that list of issues where they won't agree it with the respondent, because that happens a lot as well, because of course they feel defensive.
Yeah, and it's actually a difficult thing to do. I mean, even represented parties often struggle to get the list of issues right. Yeah,
and what I think what Moustache does is it does enable us to ask the judge to take it and help put a list of issues in place so that
at the hearing, rather than sending a claimant litigant in person off to do it by themselves.
Because that doesn't work.
Really
in my experience.
Totally agree. So, you know, maybe it's the start of a new landscape of case management, Moustache, sort of moving away from the Cox and Adecco line of cases where perhaps the EAT was moving the tribunals towards an investigative function, at least at the case management stage, and moving back towards a more adversarial function, even at the case management stage. And I think certainly for respondents dealing with litigants in person, that would be a welcome shift.
Absolutely.
Right. Should we talk a bit about anonymity?
Go on then.
We all love anonymity applications, don't we? They are a sort of a special type of application in the sense that even when a party seeks anonymity, and that's sometimes respondents, it's not so unusual for respondents to seek anonymity for witnesses or for particular individual respondent parties, but certainly it's quite common for claimants to seek anonymity. It's an unusual type of claim in the sense that whichever party is seeking anonymity, the tribunal is really almost on the other side rather than the other party. What do I mean by that? I mean, let's say I'm a respondent and I seek anonymity for an individual respondent party. I'm representing, say, 3 respondents, the company and 2 individuals, and I'm seeking anonymity for the 2 individuals because of the nature of the allegations. Quite often the claimant won't care very much, or sometimes the claimant won't care very much whether the respondents get anonymity. And conversely, if a claimant seeks anonymity, quite often the respondents don't care very much. In fact, sometimes respondents say, well, we'd rather it was anonymous because we don't really want the public knowing, these horrible allegations that are being made against our staff. But it's often the tribunal that pushes back.
Absolutely.
On that and says, no, we're not doing that. So in order to illustrate how those applications work and to have a chat about practical considerations and tactics in relation to anonymity applications, we're going to look at this case of F&J from this year. And before we do that, you're going to say something about the basics of this rule.
So the new rule 49, which is now mentioned in the ET pro forma agenda.
I mean, that's been a mixed blessing.
Well, yes, we'll talk about that in a moment. But rule 49, which deals with privacy and restrictions on disclosure. And it says that the tribunal may, on its own initiative or on an application of a party, make an order to prevent or restrict public disclosure in the interests of justice or to protect the convention rights of any person. And there's a part of that's been taken out from old Rule 50. So you no longer have if there's confidential information.
So there used to be 3 gateways. And they're interest of justice, to protect someone's convention rights, or where there's confidential information.
Yes.
That third one's gone.
And I think the reason, talking about what you were saying about why, the reason it's the tribunal pushing back is because we're talking about convention rights essentially, and they are the gatekeepers to public interest.
Yes, and freedom of expression in relation to the publicity of litigation.
So that's what they've got in their mind. It's very useful to go into the tribunal if you're making this sort of application to understand where the tribunal starts from, the position that they begin at, and that is where they're coming from.
And actually that's the new, same as the old, Rule 49(2).
Yes, which is in relation to the principle of open justice.
Right, and that's the primary consideration. Basically, the tribunal's being told in the rule that it has to consider open justice as particularly weighty and important.
What the wording is, they must give full weight to the principle of open justice and to the convention right of freedom of expression.
Right.
So that is the basic principle that all court hearings should be out in open.
Yeah.
So any order made under Rule 49 might require a hearing to be held in private, in whole or in part.
Yeah.
And that's paragraph 3. A. B refers to the identities of parties, whether witnesses or other persons referred to in proceedings, and those identities are then not disclosed to the public.
So that's what we tend to call
anonymity.
We're going to get this right. Anonymity order. That's your typical anonymity order. Is a rule now 49(3).
Yeah. So this does deal with hearings in camera, as we used to call it, but we're thinking about anonymity now because the case of F&J was about anonymity.
And it is the most common type. I mean, I think it's fair to say it's
and it is what the agenda mentions.
It does. That's right.
Right.
But there are other things that Rule 49 can do.
Subparagraph C talks about witnesses at a public hearing being identifiable by members of the public. Yeah. And subparagraph D talks about a restricted reporting order. Yeah. We don't really need to go into that, but also subparagraph E talks about the name, addresses or other private information being disclosed and redacted from claim form, other documents which would be otherwise public.
Right. So there's a sort of range of powers the tribunal has under Rule 49, anonymity, redactions, hearings in private, restricted reporting, all are various elements of keeping the identities of individuals out of the public domain, essentially.
For whatever reason, but we'll get into that because we start from the premise that tribunals are open.
Right. And so let's talk a bit, I mean, as we did with Moustache, let's start with the facts of F&J. Okay. This was a case about an academic who had an autism spectrum condition, which he said was hidden, not something that you would know about from meeting him or speaking with him or indeed employing him. Yeah. And he said that the publication of his identity in the proceedings, because it was a case about disability discrimination and his autism, his identity in the proceedings would mean that future employees, and he had, apparently we don't know what his name was because it's been anonymised, but he had an unusual name. It would have been easy, sort of unavoidable really for future employers if they looked for his name to come up with the judgment and to discover that he was had autism.
In this new world, the employers do that. They look you up.
It absolutely does happen. That's right. So the university that employed him had this condition disclosed to it, but only quite late on in the process when he felt he absolutely had to. And he said his employability would basically be destroyed if his autism was known. And he particularly made the point that he might, because of his background in academia, he might choose to go back to teaching in schools, and that school children would be extremely unforgiving of a condition like that. They'd be able to look him up and he'd never be able to control a classroom, just be impossible. Yeah. So, I mean, really, he said really significant reasons for wanting his name to be anonymised. And this went to the tribunal twice. Why? Because he had 2 appeals. Why? Because the tribunal twice refused to grant him an anonymity order. So I'll just quickly take you through those facts and then we can talk about the important decision, which is the second EAT decision, which happened earlier this year. Yeah. So first EAT hearing, refused the application. They said he had chosen to air his grievances in public by starting a claim, and that his fear, so that one thing, so first thing they said was, it's a public forum, tough. The second thing they said was that his fear about employability did not displace the principle of open justice. So they said they considered both things basically and decided on balance. Open justice was more important. And they said that they also touched on the fact that he'd not raised any clear or cogent evidence of harm to his reputation or harm to his employability by his name being in the public domain. And they pointed out that he'd got another job since leaving the university, and it didn't seem to have affected him that he had a claim in place. Now, all of that, you may be thinking, well, hang on a minute. Surely, if he's not had a trial yet, if this is just a case management hearing, considering anonymity, a new employer wouldn't know about it.
Yeah.
You or I might think, from our knowledge of the employment tribunal litigation process, and indeed the first EAT, which is a couple of years ago now, also reported decision in 2023, overturned that original tribunal decision.
Yeah.
They said, number one, that you didn't actually give him an opportunity to put forward evidence about employability. So how can you say whether or not he's got good enough evidence? That's a kind of slam dunk. You know, if you don't give him an opportunity to produce evidence, you can't criticise him for not producing it. So it went back for that. But it also went back for another reason, which I think is quite interesting and worth noting. Which is, they said, so this is the EAT in 2023, the existence of a claim in the system does not mean that the claim is in the public domain, right? Because rejection or acceptance at the initial consideration stage, entering an ET3 response, having a case management hearing, none of those things are public. All of those things are in the system. The only thing that they mentioned that was in public was a listing published, giving his name and the name of the university on a list tacked up in a tribunal centre, which is a public place, showing that a case management preliminary hearing was taking place. But that information wouldn't tell a member of the public anything about the case. Wouldn't even tell a member of the public whether it's a disability discrimination case necessarily, although there are codes, I suppose, on the board, but you wouldn't know what that means. You wouldn't know the nature of the disability or anything at all in any substantive way about the details. What they did say is that this is the EAT, that would change once there has been a public hearing and a judgment with reasons. But this case had not got anywhere near that stage yet.
No, so it was an interesting point because it's a chicken and egg thing. Because he's asking for anonymity before he gets to the point where it's a public hearing.
Right.
And then saying, well,
it's already a public hearing. And the EAT said, no, it isn't.
It's not.
That's why it's a valid point at which to make the application. So back he goes to the ET. He then does produce very detailed witness statement with annexes, setting out his personal circumstances, saying what he believed about his future employability should his autism be disclosed to new employers. And this is the point at which he makes mention of the fact that if he were to go back into teaching, pupils would be very unforgiving of a known condition of autism. And he relied on published statistics in the form of a study conducted in the United States where employers were given sort of dummy CVs of highly experienced people disclosing autism and less experienced people not disclosing autism. And employers were choosing to interview the less experienced people without a disclosure of autism. And that was a field report which was relied on by this claimant in support of his application. Again, having got all of that, the tribunal again refused his application. They said he had not provided any medical evidence of future harm if his condition were disclosed. And he didn't provide evidence about his specific future employment circumstances. And the report was about employers in America,
which was odd,
United States, not employers in the UK. So they didn't like any of that. They basically said insufficient evidence, refuse. And off it went again to the EAT
in 2025. So here we are. The EAT disagreed again with the employment tribunal. Said that they'd set the bar far too high, forcing the F to satisfy that anonymity should be granted. And there were lots and lots of reasons. I'll deal with the first issue, which is your last issue, that the report was American. They said it doesn't matter. It's fact or it's evidence.
It's the way people behave.
It's the way people behave. And they said that the tribunal wrongly focused on the need for him to provide medical evidence in support of his application. Understandable, really, because how does medical evidence help you say that you had a fear?
Yeah.
that was well grounded or justifiably objectively justifiable.
And how does a doctor know what employers are going to think about your medical condition? It's just that it's a non sequitur, isn't it?
Exactly.
Really?
Yeah. What the EAT said was that F had to prove objectively that his fears were well grounded.
Oh,
they don't have to.
Opposite of that.
It was the wrong test to say that it was well grounded, because he would not be able to prove what was going to happen in the future, and that makes sense.
It does.
He was employed, but at the point at which it went to the tribunal when he was seeking anonymity, he couldn't have proven something that hadn't happened yet.
Yeah, because at the point at which he went. At the point at which he presented his application, I think both the first and the second time, yes, he'd got a new job, but he didn't disclose his condition. So how can the new job be relevant to the question of what an employer would do with a disclosed autism condition? It was bizarre, really, to rely on the fact that a new employer had been willing to employ him when his entire point was, but this would be different in the future if I had no longer had the option of keeping that confidential.
Well, I mean, you'd have thought that the point of him keeping it confidential was so that he didn't have to disclose it to the new employer.
Exactly.
But one of his points was that there was a stigma attached to his diagnosis, and that is what the American evidence proved.
Yeah.
And if
he said that it proved.
He said that it proved. But if that fear is well founded objectively, then the tribunal has to take it into account. They can't just dismiss it out of hand. So they have to look at they have to assess his employability. Well, they don't have to assess his employability. They have to assess not whether he was employable, but whether his fear was well grounded.
Right. Well, they set out, didn't they, what the correct test is? So they basically sort of gave a shopping list of all the things that the tribunal had done that was wrong.
Yes.
All this, reliance on medical evidence, requiring him to prove his future. The future events that might happen, asking him to do the impossible, to provide evidence about what was going to happen in the future. And they said, no, that's all wrong. The correct test is actually a much lower bar. Yeah.
So he only has to prove reasonable belief, a reasonable foundation for his belief.
Right. Which is much less.
Which is relatively low. In other words, were his concerns genuinely held?
Yes. And
did they have an objective foundation?
Okay, so that really is quite a low bar.
Whether they're not just going to give out anonymity orders willy-nilly, but
no. But if you've got a genuine concern, and that's a matter for cross-examination, potentially at least in an application for anonymity, so genuine concern, and you've got there's an objectively rational, objectively reasonable foundation for those concerns, like a report carried out scientifically in which employers seem unwilling to employ people with autism. And I would imagine I can imagine in another case an individual saying, I have personal experience of this in my private life. When I tell people I'm autistic, I get a reaction which is like this. And I can, I know that people treat me differently depending on whether I've told them I'm autistic or not, for example. So again, that could easily, I think, amount to an objective foundation.
Interesting. No one knew.
No.
At all.
Yeah, that's right. So in his case, the evidence was rather different. But interestingly, the EAT was so persuaded, and perhaps reading between the lines, they did not want to send it back again to the tribunal. They decided to apply the Jaffrey test and say there is only one possible outcome here, that anonymity couldn't be contrary to the public interest, and they actually did grant him the anonymity order in the EAT without returning the case to the ET. And they relied on 2 points in relation to that, which I think are worth noting. Number one, that the identity of the names of the parties in the case were not critical to a public understanding of the case. In other words, it was going to be possible to read the final judgment in that case with F and J at the top and still understand what the case was about. And they thought that was important because effectively it facilitates open justice. You can still have a meaningful public document while still anonymising the
Yes.
names of the parties. They
Yeah.
thought that was important. So again, that's the balancing exercise between open justice
Yeah.
and his right to a private and family life, which is the convention rights point. And then so that was the first one. And they said, and this is, I suppose, another way of saying the same thing maybe, but their second reason was that the interference with open justice was relatively minor and was far outweighed by his reasonable, genuine fear of becoming unemployable, should it be aired. So it's the 2 points. It's the relatively small effect on open justice and the relatively serious effect on him if the proceedings were not anonymised.
So what do we take from this in our everyday practice then, Iris?
We've said, haven't we, that it's going to be usually the tribunal that is most interested in these applications. And quite often, as parties, we don't care necessarily that much whether the other party is anonymised. And sometimes it's even in our interest. It's sometimes in both respondent and claimant's interest to anonymise, but the tribunal may not agree. There's probably very little a respondent to such an application. So whether that's a claimant or a respondent in the case, the person who is not making the anonymity application is probably going to have a limited amount they can do in relation to it. But to the extent that the person dealing with an anonymity application made by the other party doesn't want the order made, they might want to highlight the lack of objective reasons for the application. They might, and sometimes this does happen, point to a sort of an element of blackmail, because you do sometimes get that claimant saying, well, I cannot proceed with a case unless I get my anonymity order. I will withdraw.
Yes.
It's the only option. I'm not giving the tribunal any other option. Now, that's not a killer point.
Well, F did say that.
F did say that, and there are lots of cases where that's been said. And the basic rule about that is, forget that. The question is the fear that they have objectively reasonable? And if it is, whether or not they say they're going to withdraw their claim as a result, if they do have an objectively justifiable, reasonable concern about their convention rights, and if the tribunal decides that that outweighs the principle of open justice, then the tribunal can make the anonymity order. So those are the things to focus on, to the extent that you as a party care what the outcome of the anonymity application is. And I suppose the other thing to say tactically is, if you don't care about it all that much, don't take a position. Just let the tribunal sort it out for itself. Perhaps highlight the existence of F and J 2025 so that the tribunal doesn't make a mistake, because of course you don't want an appeal about it, because that's just a waste of resources. And finally, bear in mind that the new agenda form specifically asks the question, are you seeking an anonymity order?
And we're seeing a lot more,
and we're therefore seeing a lot more of those applications. So that is going probably to become something that takes up resources, and we all want resources in the tribunal to be used as efficiently as possible. So
be aware of this case and draw it to the tribunal's attention.
Agreed.
Okay.
Final topic is the vexed but probably legally relatively straightforward question of comparators, particularly in direct discrimination cases.
All right. So we wanted to talk a little bit about Kareem and the General Medical Council, which is a 2024 Court of Appeal case, and the principles of comparators more generally. Under Section 23 of the Equality Act, we know, well, we hope we know, I know, you know, we hope everybody watching knows that there must be no material difference between the circumstances relating to each case. So you have your claimant and you have a comparator who is not materially different.
Oh, that's so easy. That's the end. I'm sure there's no case law about that.
No.
So simple.
Nothing. Only there is. There's the House of Lords, Shamoon, Shamoon and the Chief Constable of Royal Ulster Constabulary.
That's a very old established case.
Basically, it says exactly the same thing. The comparator must be in the same position in all material respects as the victim or the putative victim.
Save only that they're not a member of the class.
The protected class. So you would have somebody who is black as the claimant, and they would compare themselves to somebody with the same circumstances, or not materially different circumstances, as somebody who's, say, white. Now, it sounds really easy, doesn't it? But it's been
There's lots of House of Lords and then Supreme Court cases.
right. Yeah. Well, okay. So we've
Yeah.
got MacDonald and the Ministry of Defence, which said, with the exception of the prohibitive factor, be it sex, race, or otherwise, all characteristics of the complainant which are relevant to the way his case was dealt with must be found in the comparator. They don't have to be the same, but they don't have to be. They must be not materially different. So just going back to the statute again.
Yeah, but I think highlighting that it's the characteristics which are relevant to the way his case was dealt with.
Yes, exactly.
So let's say, for example, you're the claimant,
Yeah.
and you are saying that as a woman, you have been treated less favourably by your employer because you're a woman, and you're comparing yourself to a man, and you say there are not materially different circumstances. And I, as the respondent, say, well, that's ridiculous because that man has blonde hair and you have brown hair.
Yes.
So therefore you're not in materially the same circumstances.
Well, that's
To which the answer is, well, so what? That's not a materially relevant difference. So there is some limit to what has to be the same.
yes. But saying things like they did in Hewage and Grampian, which is a question of fact and degree, is not terribly helpful, is it? What we're actually looking at is the circumstances that relate to the discrimination.
Right. So then you turn it around and say, which, what I always end up saying to clients who say, well, I don't understand this comparator stuff, which people, is really quite difficult.
You work in Tesco's at the checkout.
Yes.
You are not the same as somebody who works in Tesco's in a lorry.
Yeah, right.
With different job, different terms, different
exactly
treatment.
And so
just different treatment de facto because you've got different jobs.
Right. So exactly. And what I try and say to clients when I'm trying to describe how comparators work is think about it from the other side.
Yeah.
Think about it firstly from the point of view of what does this claim about? What does the claimant say was done to them that is the discrimination, and what are the circumstances that they say are relevant to that act of discrimination?
Mm-hmm.
So build the comparator out of the circumstances, not the other way around.
Yes. So in my example, you've got a lady in checkout at Tesco's.
Yes.
What has she been discriminated on the basis of her sex, or on the basis of her race, or what's happened to her?
Yeah. Well, exactly. What's happened to her comes first, right? So if she says, I wanted to move from full-time to part-time and I wasn't allowed to, then the relevant circumstances might be that she was on full-time hours, that she asked to move to part-time hours, that an application was considered by her shop manager and they refused it because they said that they couldn't, they needed her to stay full-time. They couldn't accommodate part-time because of the shifts of other employees. Yeah. Well, to construct your comparator, you've got to have, let's say, a man, or if she's black, say a white employee, or if she's gay, a straight employee, whatever the protected characteristic is. And that other employee must also have been on full-time hours, asking to go part-time, being refused after an application by the shop manager. And then once you've worked that out, or sorry, you're quite right, allowed. That's otherwise it's not a very meaningful comparator. Quite right. And then from constructing that, you can then have a look, if you're acting for a claimant, to see, well, is there anybody who fits those various circumstances? And the other circumstances are not necessarily relevant, but those ones are material.
Yeah. And if there is no real comparator, then you look for hypothetical.
And that really is a case of completely structuring an unreal person based purely on what you say happened to you as a claimant.
Yes, exactly. So I think you and I have got to the bottom of it. But what did Kareem say?
Well, Kareem is one of those cases that basically involve a tribunal. Sorry if anybody was involved in this case, but who's listening, a tribunal completely messing up something that probably wasn't actually that difficult to get right. Yeah. And it ended up only getting sorted out in the court of, eventually fully in the Court of Appeal. So Mr. Kareem is a consultant surgeon. Mm-hmm. He's investigated by the General Medical Council over an incident which took place in a canteen. Mm-hmm. There is him, another employee who I think was also black, he and the other employee, black, and a white colleague. So 3 colleagues. Yeah. Two are black and 1 is white. They are all investigated in relation to this incident in the canteen. And Mr. Kareem compares himself to his white colleague because he says that his investigation took 3.5 years to be conducted.
Yeah.
And then he was exonerated.
Yeah.
He was actually not found to have committed any misconduct. He was not found to be unfit to practice. But his white colleague was investigated much more quickly and exonerated much, much more quickly, I think within a year or so, instead of 3.5 years.
Yeah.
And what he was complaining about in his claim was about the delay in completing his investigation. And he alleged it was race discrimination, and he compared himself to the white colleague whose investigation was completed much more quickly.
Yes.
The Court of Appeal recited those cases that you and I have just been chatting about.
Yeah.
They said there has to be no material difference between the circumstances of each case. And they said, unless the relevant circumstances are the same, the tribunal has to explain why it is considering a comparator to be in not materially the same circumstances. To be in materially not different circumstances, if that is what the tribunal is going to decide. And in this case, the tribunal said, well, we find that Mr. Laniado was the name of the comparator, that Mr. Laniado was in materially not different circumstances. They don't explain why they find that he was in not materially different circumstances. And that was an obvious error of law because although they were both initially referred from the same incident, by the time that Mr. Laniado's case was dropped and Mr. Karim's case was continued, their circumstances were completely different because there'd been an external investigator who had identified completely different findings in relation to each of them. And the findings against Mr. Laniado were such that the investigation was no longer required. The different findings related to Mr. Karim were such that the investigator did recommend continuing the investigation against him. So you would have thought that's squarely material difference between him and the white colleague, that the investigation findings about each of them were completely different. And in those circumstances, the trust continuing an investigation into Mr. Karim and stopping the investigation into the white comparator was straightforwardly explicable. And if the tribunal was going to find that they were in fact in not materially different circumstances, it should have explained that very clearly, and it just didn't. It just didn't at all. So the case itself doesn't tell us anything surprising or new, but it's a good illustration of messing up the comparators. It is. And really, I want to say something about the statistics, which is the other thing in our list of tactical considerations that we're talking about in this session. But then we'll perhaps have a chat about what to do if you're a claimant and you've got someone like Mr. Laniado who is not a comparator, technically speaking. Can that still be a useful piece of evidence for your case? So let's come back to that, but let's talk about statistics. This is another way in which the Karim case is just straightforwardly wrong in the tribunal, and perhaps just a useful illustration of how not to do it when it comes to statistics. Now, we know, don't we, that in employment discrimination cases, actually particularly in indirect discrimination, but sometimes also in direct discrimination cases, statistics can be relevant. And the way in which they tend to be relevant is in the sense that you have the Madarasi case, which says that a difference of protected characteristic and a difference in treatment is generally not going to be enough to establish a shifting of the burden of proof for direct discrimination. There has to be something more. And it's not unusual for claimants to say, well, there's something more I have to present to you, the tribunal, is that this employer has a track record of mistreating Black employees. That's very statistically, for example. And in a similar way, I suppose what Mr. Karim was trying to do with his statistics is to say, well, the reporting into race statistics, and particularly BAME versus white registrants with the General Medical Council, is, he said, that registrants from a Black and minority ethnic background, statistically, are much more likely to receive sanctions on their fitness to practice.
More likely to be reported, more likely to receive sanctions.
More likely to be reported, absolutely, and then more likely to receive sanctions than white or non-BAME registrants to the General Medical Council. To which the obvious question is, hang on, that's not your case, Mr.
How
Karim.
is that relevant to delay?
How is that relevant to delay? Because yes, you were referred, but so was Mr. Laniadi, who was white. And in the end, both of you were exonerated. The real issue, Mr. Karim, in your case, was the delay in considering your, in investigating your circumstances. And actually, the Court of Appeal made a really straightforward point, which was if you had presented statistics to the tribunal that suggested that Black and minority ethnic referees, people who had been referred to the General Medical Council, tended statistically to have their cases investigated and delayed for much longer than white people, that would have been a relevant statistic. We that would have been a valid thing to weigh in the balance when considering whether there was more than just a difference in race and a difference in outcome. But he didn't have that statistic. I mean, maybe that statistic exists. Who knows?
What was he actually trying to prove though? Because he said it went to the comparator, but it went to unconscious bias, he said. Right,
he said so, but the Court of Appeal said that would be the case if the statistics were about the delay.
But they're not.
But they're not.
No.
I mean, I do wonder. Maybe worth having the chat about this. And this is not what happened in the case, and this is not what the Court of Appeal said. But perhaps if the tribunal had done a better job of expressing themselves in the judgment, and perhaps if there had been more factors weighing in favour of Mr. Karim, perhaps if he had a better comparator, if he presented his case in a more persuasive way. I mean, I don't for a moment say anything about his particular presentation. We only know what the tribunal said about it, which was not very well presented by the tribunal as a judgment. But let's imagine he had better comparator evidence. Maybe he was a better witness. Maybe the witnesses attending the trial on behalf of the General Medical Council were not very good and came across as quite guarded and defensive and perhaps lacking credibility under cross-examination. I think maybe taken with that, he might have been able to say, oh, and by the way, there is this evidence that generally more registrants from a BAME background are referred to the GMC. And then when they are referred, the GMC tends to discipline them more than it does white people who have been referred. And that in the round, with all the other interesting, valid, persuasive evidence presented by Mr. Karim, might have been part of the mix. That's absolutely possible. The problem Mr. Karim had was that the tribunal didn't identify a nice, juicy list of good evidence to which to add this statistic. And they really didn't have a lot that they had identified.
It felt to me, reading it, that the problem was really that they needed a hypothetical comparator, and this is the problem we come to in terms of practicalities.
Yes, absolutely. So what to do, first of all, if you're a claimant, you have to really interrogate your own comparator. If you've got an actual comparator that you're relying on, really think about whether that's a valid comparator by reference to the test in section 23 of the Equality Act and all of those cases, Shamoon, MacDonald and Huage that we mentioned, and how a comparator should be identified. For a respondent, you're looking at the same set of cases and you're challenging that comparator. I think tactically you don't necessarily spell out at an early case management stage that you dispute it. You allow the claimant to set out their comparators, and then in submissions at trial you say, well, obviously these people are not valid actual comparators because their circumstances are not materially different. But as a claimant, what do you then do if you don't have if you have a suspicion that your real people that you've got around you to choose from are actually not valid actual comparators? Well, firstly, you construct a hypothetical. And you do that by reference to what you say are the relevant circumstances of your detrimental treatment, of your discriminatory, less favourable treatment. That should be capable of being done, because that is not a case of identifying a real person. By definition, that's about creating a pretend person whose only different materially different circumstance is their race or their sex or whichever protected characteristic. And the other thing to say, tactical basis from a claimant point of view, is don't be afraid of saying, okay, this person, John Smith, is not an actual comparator as defined in Section 23 of the Equality Act. But the fact that John Smith was treated so very differently to me in circumstances, okay, they're not materially not different from mine, but they're quite similar. And you would expect that if what they're saying is right and race was no part or sex was no part of the way that I was treated, you'd expect John Smith to have had somewhat similar treatment to me, and John Smith just didn't. They treated John Smith completely differently to me, and so there's what we sometimes call that an evidential comparator. Now, it's not strictly speaking a comparator, but you can raise that the treatment of that person as being something that the tribunal should take into account. And tactically speaking, that's something that I don't see a lot of claimants doing, and it is something that claimants should be doing more of, because it can be actually quite a powerful evidential point to add to the mix.
Okay.
Right. I think that's that concludes our discussion of case management lists of issues, anonymity, applications, comparators, and statistics. I'm just going to have a quick look and see whether we've had any questions. And I don't think that we've had any questions. I guess that probably means, Karen, that everything we've said has been completely clear and straightforward.
Of course, absolutely.
And everybody is, fully understands it and is totally happy with the tips and tricks that we've discussed in relation to those issues.
Okay.
So I think probably.
Would you like to close out? Or
What do you want to do it?
All right.
Go on.
Okay. Well, thank you for attending. Any unanswered questions will be followed up by email. If you want to send in later, that's fine. If you're watching the recording, then email them through to events@42br.com. The recording is available, or will be available, on the website and YouTube channel.
We've got a very busy YouTube channel, so there's lots of things to see on there. And in a few days,
we'll be
that will include this webinar.
Send any feedback if you have any. The next session in the series will be tears, and tribunals, injuries, feelings unpacked, with Michael Salter and Amritpal Baku on 24th of June. So excellent. Enjoy that. Yeah, well, please, what do we say? Log in, dial in, join us. Let's say join us. Join Amrit and Mike for the next exciting instalment of our employment law webinars. Thank you. Thank you, everyone. Bye-bye.